The Divorce, Dissolution, and Separation Act 2020 removed the requirement to prove fault to end a marriage. Instead of litigating over unreasonable behavior or adultery, the process now requires a simple statement of irretrievable breakdown. Getting a divorce is now largely an administrative process running on a set clock. Separating the money, property, and pensions, however, is a separate and highly complex challenge. To manage a case effectively, practitioners must navigate two parallel but distinct procedural tracks simultaneously. The top track is the strict statutory timeframe for obtaining the actual divorce order. The bottom track is the financial remedy procedure, governed by the Family Procedure Rules 2010. This creates an immediate procedural tension. The administrative divorce track moves rapidly, while the investigative financial track can drag on for months or years. If the fast track outpaces the slow track, vulnerable parties risk losing crucial financial protections. To prevent this, practitioners use Section 10 of the Matrimonial Causes Act 1973 as an emergency brake. Mastering family law requires knowing exactly how these two tracks operate, and crucially, knowing exactly when they must collide. Look at the divorce track. The timeline starts the moment the application for a matrimonial order, known as Form D8, is issued by the court. Under the current law, this application can be made jointly by both parties, or solely by one spouse. Once issued, a strict statutory waiting period of 20 weeks begins immediately. Parliament designed this as a built-in cooling-off period. It gives the parties space to reflect and potentially agree on future arrangements before the legal process advances. When those 20 weeks expire, the applicant can request a conditional order. The conditional order signifies that the court accepts the marriage has irretrievably broken down. However, the marriage is still legally intact. Following the pronouncement of the conditional order, a second mandatory waiting period of 6 weeks and 1 day applies. Only after this final wait can the applicant apply for the final order. The final order is the legal decree that definitively terminates the marriage. This track operates like a highly predictable conveyor belt. It runs its course entirely indifferent to any external disputes between the parties. Financial resolution requires its own distinct initiation. Before issuing a financial application, a party must attend a Mediation, Information, and Assessment Meeting, or MIAM. The court requires evidence of this meeting to ensure the parties have explored alternative dispute resolution before litigating. There are specific exemptions to this requirement. A documented history or risk of domestic abuse, for example, bypasses the MIAM entirely. To formally initiate financial proceedings, the applicant issues Form A. This triggers the bedrock of financial proceedings, the duty of full and frank disclosure, executed through the exchange of Form E. Both parties must list all assets and liabilities. If a party hides wealth, the court can draw adverse inferences, penalize them in costs, or set aside final orders. The first time the parties face a judge is the first directions appointment. This is an active case management hearing. The judge determines which assets need formal valuation and controls the instruction of joint experts, like pension actuaries or property surveyors. Once the evidence is gathered, the case moves to the financial dispute resolution hearing. This hearing operates on a without prejudice basis. The judge gives a non-binding indication of what a fair outcome might look like to facilitate a negotiated settlement. If the parties reach an agreement, they draft a heads of agreement or a rose order, which is then formalized into a binding consent order. If negotiations fail, the case escalates to a contested final hearing, where a different judge imposes a binding financial settlement. Unlike the administrative divorce track, the FPR 2010 track is investigative. It is heavily managed by the court and highly vulnerable to delays caused by non-disclosure or complex asset valuation. Here is the central procedural danger. The 26-week clock on the divorce timeline can easily expire while the financial disclosure is still bogged down in disputes. If a final order is pronounced before the finances are settled, a vulnerable respondent loses their status as a spouse. This can instantly extinguish rights to occupy the family home or claim against a former partner's pension. To prevent this prejudice in cases where one spouse makes a sole divorce application, the respondent can invoke Section 10 of the Matrimonial Causes Act 1973. The respondent formally applies to the court to evaluate their financial position before the divorce is finalized. This application can only be lodged after the conditional order has been pronounced. Once invoked, Section 10 holds absolute statutory power. The court is legally prohibited from making the divorce order final. The blockade remains in place until the court is satisfied that the financial provision made for the respondent is reasonable and fair, or that no provision is required. Strategically, this forces a non-cooperative applicant to engage constructively with the financial track. They cannot get their divorce until they provide transparent disclosure. Section 10 is a suspensory mechanism, not a permanent veto. It delays the final order until equity is achieved. It serves as the critical bridge, ensuring the administrative speed of the divorce track does not overrun the equitable requirements of the financial track. All of these procedural mechanics serve a higher statutory purpose. When the court assesses what constitutes a fair financial outcome, it relies on Section 25 of the Matrimonial Causes Act 1973. As this framework shows, decades of case law have distilled Section 25 into three core objectives: needs, compensation, and sharing. The principle of needs, securing housing and income for the parties and any minor children, is the dominant factor. In cases with limited assets, needs will override all other considerations. Simultaneously, the court applies Section 25A, the clean break principle. The court has a duty to consider terminating mutual financial obligations between the spouses as soon as it is just to do so. The dual-track system serves these broad principles. The 2020 Act allows parties to legally separate without wasting court resources on assigning blame. Meanwhile, the family procedure rules and the statutory safeguards of the 1973 Act ensure the resulting separation is structurally secure. True procedural mastery is knowing the timelines, but effective representation requires tactically managing the intersection of administrative speed and financial equity to ensure long-term client protection.